Assalamualaikum dan selamat sejahtera. My group, Naim, Sanjun and Derek, we will be presenting about construction law and contract. My group will be presenting from clause 33 until clause 48. Clause 33, deduction of money due to contractor. In contract PWD 203A, the government or the client can deduct any owed money from contractor payment without notice or detailed documents. In PAM 2018, the client can deduct money from the contractor payment. In CIDB 2000, when the client makes the deduction, it is considered as payment made from the contractor towards the client. The difference between these three contracts is that in PWD, they are not strict about deducting money from contractor payment, while in PAM, they are very strict about the, deducting the contractor payment. A full detail of the deduction is needed, such as a notice 28 days before the deduction and how the contractor can dispute this deduction. While in CIDB 2000, they only emphasize on the status of the payment. A relevant case that is related to this clause is Pembinaan Lau Tak Chu and Sons Sasbadi Berhad versus Dr. Leila Medical Center Sasbadi Berhad 1995. The summary of this clause is that in PWD 203A, they are very straightforward about it and not strict about it, while in PAM 2018, they are very strict about deducting payment from contractor payment. In CIDB 2000, they focus more on the status of the payment when the client deduct the money. The key difference between these three clauses is that PWD is not strict, PAM is very strict about it, and CIDB focus more on the status of the payment. Clause 34, prime cost and provisional sums. In PWD 203A, it talks about PV and PC sum costs and how extra instruction can increase the amount. While in PAM 2018, it talks more about architect instruction towards the PV and PC sums. CIDB 2000 is similar to PWD 203A that talks about PV and PC sums. The difference between these three is that PWD talks details about the PC and PV sums, while PAM only talks about the architect instruction towards the PV and PC sums. CIDB 2000 is similar to PWD, but it also talks about how the client can reject any tender, even the lowest bidder. The relevant case for this clause is Pali PTP Sasbadi Berhad versus Bond M&E Sasbadi Berhad 2003. The summary of this clause is that PWD, it talks details about the PV and PC sums, while PAM only talks about architect instruction on PC and PV sums. CIDB 2000 is similar to PWD 203A with a bit more detail about how the client can reject tender from the lowest bidder. The key difference between these three contracts is that PWD is detailed, PAM is not detailed, CIDB is detailed, similar to PWD. Next clause. Clause 35, materials, goods, and workmanship. In PWD 203A, contractor must follow the specification and in accordance with the standard of workmanship in the industry. PAM 2018, it talks about the quality and standard that shall be followed by the contractor in the contract and the contract and the architect. CIDB 2000 is similar to PAM. The difference between these three contracts is that PWD 203A talks about how the contractor must follow the specification and anything stated in the contract. PAM is similar to PWD but also talks how we must follow architect instruction. Also, in PAM 2018, it doesn't state anything about taxes. CIDB 2000 is similar to PAM but also talks about testing. The relevant case for this clause is PAM Engineering and Construction Sasbadi Berhad versus Haji Ahmad Rice Mill Sasbadi Berhad, 1966. In this clause, it in this clause, the summary for PWD, it talks detail about material, goods, and workmanship in accordance to contract. It also talks about the taxes that the contractor needs to pay. In PAM 2018, it talks detail also about the materials, goods, and workmanship, but it doesn't talk about taxes that the contractor need to pay. In CIDB 2000, it is same as PAM, but also state about testing site. The key difference for these three contracts is that PWD is detailed, PAM is not as detailed as PWD, CIDB is detailed similar to PWD. Clause 36, Inspection and Testing of Materials, Goods and Equipment. PWD 203A, it talks about how the inspection work is proposed and carried out by the contractor. PAM 2018, it talks how the architect instruct the inspection work. CIDB 2000, it talks about testing and inspection work that is done after work completion. The difference between these three contracts is that PWD talks about if the inspection work is done and the work done by the contractor is according to the standard, then the government pays for the inspection. But if the work that is done by the contractor is not in comply with the standard, then the contractor pays for the inspection work. In PAM 2018, the inspection work is added to the contract sum unless it is already allocated in the bill of quantities or the works are not in accordance with the contract. CIDB 2000, it talks more about the SO must attend during the time of testing. If the SO doesn't attend during the time of testing, the contractor can proceed with the testing and later send the SO the report of the test. The relevant case for this clause is Kerajaan Malaysia versus Kumpulan Leases Sasbadi Berhad 2020. The summary for this clause is PWD emphasizes more about inspection and testing responsibility. PAM is similar to PWD but also emphasizes on the responsibility. CIDB 2000, it talks more about the SO work. The key difference between these three contracts is PWD detail, PAM is detailed, and CIDB more about test report mainly. Clause 37, Constructional Plan, Equipment, Vehicles and Machineries. In PWD 203A, it talks more about the contractor responsibility to handle the plant, equipment and machineries. In PAM 2018, it says only general info about the contractor that the contractor must follow in accordance to contract document. CIDB 2000, it talks about hire agreement. The difference between these three contracts is PWD talks very detailed about the plant, equipment, and machinery, while PAM only general info about the plant, equipment, and machineries. CIDB 2000 only talks about the hire agreement. The relevant case for this clause is Kerajaan Malaysia versus Kumpulan Leases Sasbadi Berhad 2020. The summary for this clause is PWD is very detailed about plant equipment, vehicles and machineries, while PAM only talks general about it, mostly asks the contractor to follow the contract document, while CIEB 2000 mostly talk about hire agreement. The key difference between these three contracts is PWD detail, PAM general info, CIDB hire agreement on the Clause 38 possession of site. PWD 203A talks very detailed about it, emphasizes on date of completion, performance bond, and etc. PAM 2018 talks about possession date, termination, and completion. CIDB 2000 is similar to PAM. The difference between these three contracts is PWD is very detailed about possession of site, while PAM is also considered detailed about the possession of site. CIDB 2000 is similar to PAM. The relevant case for this clause is Tan Hock Chan versus Ho Tae Seng, 1980. The summary for this clause is PWD is very detailed about site possession, while PAM is not as detailed as PWD, and CIDB 2000 is similar to PAM. The key difference between these three contracts is PWD very detailed, PAM detailed, CIDB detailed.
Hi, good morning, Madam Fatin and everyone. My name is Shangjun. Now, I will be presenting on clauses 39 to 43 under PWD 203A, while at the same time making comparison with PAM 2018 and CIDB 2000. Overall, these clauses mainly deal with the completion of works, damages for non-completion, sectional completion, partial occupation, and also extension of time. Okay, now, let me start with clause 39. In this clause is mainly about completion of work. In simple terms, the contractor must complete the project on time or within any approval extension. But what is more important here is the concept of practical completion, because it does not mean the project is 100% perfect. Instead, it means the building is complete enough to be used for its intended purpose, even though there may still be minor defects. So the logic here is actually practical. The employer can start using the buildings without waiting for very small issue to be fixed. Compared to PAM, which depends more on the architect's opinion, PWD is stricter because everything must follow a formal inspection and certificate process. The relevant case of the Clause 39 completion of works is Jarvis and Sons Ltd versus Westminster Corporation. Then, moving on to the Clause 40, this is about LAD, which is damage for late completion. Now, one key thing here is that under PWD, LAD does not just happen automatically. Instead, it only starts after the certificate of non-completion is issued. So this creates a clear trigger point. The reason behind this is to ensure fairness, because the contractor should not be penalized unless the delay is formally confirmed. However, if we compare this with PAM and CIDB, they are stricter in another way, because LAD can apply once delay happens even before any certificate is issued. The relevant case of the Clause 40 damages for non-completion is Cubic Electronic Sdn Bhd versus Mars Telecommunication Sdn Bhd. Next is Clause 41, which introduces sectional completion. This basically means that different parts of the project can be completed at different times. What is interesting is that each section is treated almost like a separate contract. So things like LAD and defect liability period are applied separately. The advantage of this is flexibility, especially for large projects. But at the same time, PWD still keeps control by not releasing the performance bond until the entire project is completed. So compared to PAM, which is simple, PWD is more controlled and structural. The relevant case of the Clause 41 sectional completion is Kerajaan Malaysia versus Global Upline Sdn Bhd. After that, Clause 42 talk about partial occupation. This allows the employer to use part of the building before everything is completed. Now, this sounds efficient, but there is a condition under PWD, which is that the contractor must agree first. The reason is quite logical because early occupation may disrupt ongoing works. At the same time, once a park is occupied, the defect liability period for that park will start, and FAT will also be reduced accordingly. Compared to BAM and CIDB, PWD is more protective toward the contractor here because consent is required. Relevant case of the Clause 42 partial occupation or taking over by government is Kerajaan Malaysia versus Global Upline Sdn Bhd. Finally, Clause 43 is about delay and extension of time, EOT. This is very important because it protects the contractor from being unfairly penalized. However, the contractor must follow a strict process, which includes giving early notice and providing full details. If not, the claim may be rejected. So, the key idea here is that even if the delay is not your fault, you can still lose your entitlement if you fail to follow the procedure, compared to PAM, which is very strict on notice as a condition precedence. CIDB focus more on mitigation, meaning the contractor must actively reduce delay. The relevant case of the Clause 43 delay and extension of time is PSI in Control Sdn Bhd versus Icron International Limited. That is all for me, and I will now pass to Derek to continue the presentation. Thank you.
Hi, my name is Derek. I'm going to present on Clause 44 to Clause 48 from PWD 203A, focusing on the key contents, comparison across PWD 203A, PAM 2018, and CIDB 2000, as well as related case law to support understanding. Starting with Clause 44, claim for loss and expense. This clause set up the mechanism for contractors to claim additional loss and expense arising from events that disrupt project progress. Under PWD 203A, this is directly governed by Clause 44. For PAM 2018, it addresses the same matter in Clause 24, concerning loss and expense caused by matters affecting regular progress. And CIDB 2000 covers it through Clause 31 and Clause 32 on claims and claim procedures. A major distinction lies in the notice period. PWD 203A and CIDB 2000 require notice within 30 days of the event, while PAM 2018 requires 38 days from the architect's instruction. In terms of payment, PWD 203A allows the certain amount to be added to the contract sum, while PAM 2018 and CIDB 2000 include validated claim in the subsequent interim certificates. The case of Syarikat Bina Darul Aman Berhad versus SKS Pavilion Sdn Bhd 2019 provides important guidance on the practical application of such claims. Moving on to the Clause 45, investigation by the government and other persons in case of accident, failure, or other event. This clause defines the authority responsible for investigating accident, failure, or other incident on site. For PWD 203A, Clause 45 granted such powers to the government, its employee, or authorized person, and PAM 2018 distributes similar responsibilities across architect's instruction in Clause 2 and statutory obligations in Clause 4, while CIDB 2000 addressed this within site administration provisions under Clause 4 and Clause 13. The main difference central on the authorized investigation body. PWD 203A emphasized government authority, PAM 2018 placed this with the architect and consultants, and CIDB 2000 assigned it to the superintending officer or authorized personnel. The case of Jabatan Kerja Raya Malaysia versus Pembinaan Mega Jaya Sdn Bhd 2022 clarifies the scope of these investigation powers under standard contracts. The next is Clause 46, Access for Works, which regulates access rights to the worksite for authorized representative. In PWD 203A, Clause 46 granted the superintending officer and their team unrestricted access at all times. PAM 2018 provides similar unlimited access under Clause 9 and Clause 29, while CIDB 2000 limits access to reasonable times and hours under the site administration and other contractors clauses. Legal clarity for this provision is supported by the case of Jabatan Kerja Raya Malaysia versus Metro Construction Sdn Bhd 2023. The next will be clause 47, subcontract or assignment, which control the contractor ability to subcontract works or assign the contract. PWD 203A requires the contractor to obtain the superintending officer's written consent before subcontracting any part of the works, and such consent must not be unreasonably delayed. For PEM 2018, the contractor shall not subcontract at all unless otherwise stated. CIDB 2000 also requires consent for part subcontracting, but no consent needed for labor supply, standard materials, or nominated subcontractor. This is supported by the case of Kinu Sendirian Berhad versus Jabatan Kerja Raya Malaysia 2025, which clarifies the legal requirements for valid subcontracting consent. Finally, Clause 48, defects after completion, governing the defect liability period and the contractor obligation to rectify defects post-completion. PWD 203A provides a standard 12-month defect liability period and requires rectification within 3 months of receiving the schedule of defects. PEM 2018 applies a similar defect period, but demand rectification within 28 days of instruction. CIDB 2000 allows the superintending officer to issue rectification instruction during or within 14 days after the defect period, without setting a fixed maximum timeline for correction. The case of Badan Pengurusan bersama Tropicana Bay Resident versus Mutiara Metropolis Sendirian Berhad 2024 reinforced the contractor ongoing liability for defect during this period. In summary, Clause 44 to 48 address essential aspects of construction contract administration, including financial claims, incident investigation, site access, subcontracting controls, and post-completing defects. Understanding these differences is important for both employers and contractors to manage their rights and obligations effectively. That's all for us. Thank you for watching.